So morning everybody and welcome to October's coffee break briefing. Overview of today then, we'll talk about avoiding tribunal claims. I'll start with a short presentation on the role of ACAS and how early conciliation A is supposed to work and B in some cases does actually work. I'll do a short bit on pre-termination discussions, looking at the difference between without prejudice conversations and the statutory concept of protected conversations within the employment sphere. And we'll have a quick explore at the end of some ideas on settlement agreements. I'm not going to do a huge amount of detail on settlement agreements. I'm not going to go through kind of their structure or the key terms or anything like that. As always, this is an overview session designed to give some general information that might be useful. So I'm going to talk about them in a very sort of broad stroke approach. If anybody does want a future session that looks at settlement agreements specifically and more detail around those, more than happy to do it as a dedicated session because there is a lot to talk about on them in and of themselves. As I think I mentioned in a previous session, we are cycling through the employee life cycle with these. As you've probably noticed, having done a session on termination and now settlement, we're moving towards the end of those sessions. In terms of our plan for them, the mediation one done next month by Nathan, and then what will probably be December's for me looking at post-termination issues, is going to bring us towards the end of our plan cycle. So moving forwards, if anybody's got any suggestions for topics, please do feel free to let us know. So the role of ACAS and early conciliation in disputes. Yes, we have obviously now reached the point where there is a potential legal issue arising between employer and employee. It may be because after last week's session, you have terminated their employment. It may be that there is a discrimination issue that's arising, the individual's still employed. One of the first things that an employee will encounter when they start Googling, when they start researching what is happening to them or what they believe is happening to them, other than solicitors trying to get their business, will be signposting towards ACAS and the possibility of early conciliation. So who are ACAS? Well, for those of you not familiar with them or who have just always called them ACAS, they are the Advisory, Conciliation and Arbitration Service. Strictly speaking, they are a non-government organisation, but government funded, and their primary purpose has always been to try and resolve employment disputes before they make their way to the courts and tribunal. When they were established, and indeed when employment tribunals were originally established, I think there was this idea that most employment disputes would be relatively straightforward and relatively easily resolved. Parking ACAS for a second and thinking about the employment tribunal itself, we know that that's not the case. The vast majority of employment claims are not straightforward pay claims. They are not contractual wrongful dismissal claims. And the very fact that as representatives, we often have to engage counsel to ensure that representation on the day is done in a certain way, says that the employment tribunal is a more complicated sphere than I think was first envisaged. The employment tribunal deals with massive contemporary social issues on a regular basis. It's where we obviously see discrimination claims and the majority of Equality Act claims kind of being resolved at first instance in a way. Interpretation of the Equality Act is fairly common. In the employment tribunal, as we all know, definitions of disability. I've talked on the Taylor and Jaguar Land Rover case where the question of gender reassignment was decided at first instance for one of the first times. And I think the point I'm making here, the employment tribunal is a complicated jurisdiction. Employment law is not pay claims and basic contract claims for the most part. The extension of that, of course, is that while ACAS in principle are quite effective when dealing with pay disputes, when dealing with relatively straightforward cases, their role becomes a little bit more complicated in kind of those discrimination cases or more complicated unfair dismissal. And those of you who have been on either side of dealing with ACAS will know this. That said, they do have a function, they do have a role. Most of us will be familiar with them from an early conciliation point of view, which I'll spend most of the first part of this morning talking about. But they do also provide a series of other services and have a series of other functions. They will undertake collective conciliation as well as the early individual one. So collective conciliation, of course, potential group claims where you may have 2, 3, 4, 20 people involved in the same dispute. They will quite happily act as a form of representation for all of those people in a collective discussion. They do have an arbitration function. So in theory, at a very early stage, you can get ACAS involved to actually arbitrate on the dispute and make what is in effect a formal decision about the dispute. It's obviously not a judicial outcome. It's obviously not necessarily enforceable or mandatory, but they do have that function. They are able to look at the papers and representations in a dispute and make a determination as to outcome in some cases. ACAS do also provide training and other resources. So if you or where you're a HR professional contracted by third parties, your clients don't have those internal resources, ACAS do provide template letters, template policies, guidance on how things should and should not be conducted. We've talked in previous sessions about how failure to comply with ACAS standards, and again, I'll come onto those in a moment, can lead to an uplift in the employment tribunal, not following a grievance process correctly, not conducting a fair disciplinary hearing, for example. The documents that ACAS produce obviously are intended to be compliant with their own minimum standards, and therefore logically using them means you are doing the absolute minimum. What they are for the most part is very templates. If you're going to use them, you will need to tailor them to your specific industry and your specific circumstances. In terms of training, yes, ACAS do facilitate various forms of training. The other thing, of course, that they are known for, as I just said, is producing a combination of regulatory guidance and broader guidance. So the big ones being the ACAS Codes of Conduct and Code of Practice when it comes to disciplinaries, investigations, flexible working requests, all of those ones that the tribunal will take into consideration when making decisions. Where people will also have been familiar with some of the guidance that ACAS produces was, we're now talking 4 years ago, of course, COVID, furlough, they produced a lot of guidance at that time around health and safety at work and things like how to deal with people who are refusing to come in those circumstances. So they do occasionally provide all of this additional information above and beyond the early conciliation that most of us will be familiar with. But it's early conciliation that we're most interested in because that's where we're most likely to encounter them. Early conciliation, where it sits in the tribunal process then, is it is a mandatory step for an employee before a claimant can issue a tribunal claim. The obligation, and it is set out in the legislation, is that they must have notified ACAS prior to issuing their claim in most circumstances. There's a couple of very, very isolated situations where they don't have to, but for the majority of claims, for the majority of circumstances, they need to have at least notified ACAS of the existence of the claim. Fine, no issue with that. What it means is that for the claimants, for the employee, if they do not have the ACAS certificate that is produced at the end of the conciliation period, the tribunal may well not have jurisdiction to hear their claim. So this is really useful for us to know because, of course, one of the first couple of things you're always going to check when receiving a claim form, is there an ACAS certificate and do we agree with the dates on it? And secondly, of course, is the claim in time considering ACAS, which again, I'll come on to in a moment. As I say, the obligation, the legal requirement is only to notify ACAS. There's no requirement for either party to actually engage or to attempt conciliation through the ACAS process. An employee is absolutely entitled to phone up ACAS and say, I want to notify you of a potential claim. I'm not interested in the early conciliation process. I want to just have the certificate issued so that I can prepare and file my claim. Nothing wrong with that. It happens quite regularly, particularly where those discussions have already been attempted. So if you've got a claimant, an employee who has already gone through a grievance process, gone through an appeal, maybe already tried a conversation with the employer to resolve, maybe solicitors have already been engaged in the process, they may well just do that notification and ask for immediate issue of the certificate. I've said at the bottom there are situations where an employer can also request the involvement of ACAS. There's one where it happens reasonably regularly, and the other situation, I can't imagine why most people would do it. So the first one is we've reached a resolution for something with an employee. There's no lawyers involved in the process for whatever reason, and we want it formalised in a document. It's absolutely fine to contact ACAS and say, look, I've reached an enhanced redundancy agreement maybe with an employee, or we've reached an exit strategy in the middle of a disciplinary process and we want it formalised, can you assist? Yes, and they will, and the process will follow very similarly to things I'll talk about in sort of 5–10 minutes time. The other situation where this potentially arises is that in theory, if as an employer you are aware of a potential claim, you can in fact contact ACAS to start the early conciliation process. I can think of lots of reasons not to do that, least of all that it's the employee's responsibility to make sure they tick all of their legal boxes. Secondly, that no doubt it gives the employee additional time to deal with the situation, and of course it carries the risk that you, having notified ACAS, they will contact the employee and basically say to them, your employer thinks you might have a claim against them. So I can't work out many situations where you would want to do this or where there is any obligation for you to do so, but you can if you so wish. I can possibly think of a situation that it might arise where, as an employer, you've got a counterclaim against an employee and you think the best way to resolve it is through conciliation. There are slightly different rules when that happens, least of all if it's the employer who contacts, it doesn't change or pause the limitation period for the employee. But again, we'll come on to that shortly. And that's kind of the gist of early conciliation, really. It's a process that has to happen. It's, in theory at least, no obligation, as I say, for the employee or indeed you as the employer to engage. And there's no penalty, of course, for failing to do so. Not discussing things through ACAS is very, very unlikely to amount to unreasonable behaviour later down the line. And as we'll come on to shortly, discussions with ACAS are confidential and generally inadmissible anyway. So it's there. It is a process that occasionally leads to resolution and sometimes is very successful, but absolutely no obligation, no guarantee that it will resolve the dispute. So what's the effect of engaging in the early conciliation process? So when an employee contacts ACAS in the first instance, they will go through a series of questions with an individual at ACAS. The big one will be, do you want to attempt to resolve this situation with your employer? Do you want us to start the early conciliation period? If that early conciliation period is started, it now lasts up to 6 weeks. It used to stop automatically at 4. That has been extended. In my experience, all that extension has done is simply extend the early conciliation period by 2 weeks. It doesn't seem to have made any difference as to whether things get resolved or not. And I think one of the biggest issues with ACAS at the moment is that, just like any organisation that is, well, actually government funded or private, I don't think it matters at the moment, they are overworked, understaffed. And it is perfectly possible that that 6-week period will be halfway through by the first time anybody has actually spoken to a conciliator. I have had a recent case where exactly that happened. I filled in the notification myself on behalf of a claimant. It took 3 weeks for the conciliator to contact me. Well, that's 3 of those 6 weeks already gone. If a resolution isn't reached at the end of that 6-week period, ACAS will automatically produce the certificate that is then required by the claimant to refer to in order to issue their claim. Either party, or indeed ACAS off their own backs, can stop that period early if it's obvious that resolution is not going to be achieved between the parties. There is no way to extend that 6-week period. ACAS can continue to be involved beyond that 6 weeks. They still have the power, they still have the discretion to engage and to continue to attempt to mediate and reach a resolution, but it doesn't count as part of the early conciliation period. The 6 weeks is a maximum. The useful thing about this, particularly for a claimant, is that what this does is has an impact on their limitation period. So the ordinary limitation period in the employment tribunal, as most of us would know, is within 3 months of the thing you're complaining about. And what that means in practice, of course, is we count 3 calendar days from, say, the date of termination. They have to issue their claim the day before that. There are 2 ways that the engagement with ACAS can affect this. I don't think it's absolutely vital that all of us know and understand these, because it is complicated, but it is useful to you when you receive a claim form to have some idea as to how the ACAS period might have affected it. And the 2 ways that this sort of plays out is, 1, that entire 6-week period is in effect within time. So they contact ACAS early in that 3-month period, and the 6-week early conciliation period finishes before their ordinary limitation date. Okay, so for example, they get sacked on the 2nd of January. Their ordinary deadline date would therefore be February, March, April the 1st, 3 months less 1 day. If they contact ACAS in mid-January, the 6-week period will finish at the end of February. And what's happened there is, in effect, the amount of time that happened before they contacted ACAS stops at the day they contact. We have the 6 weeks, and then that period picks up again, not counting those 6 weeks. So what they've got, 3 months plus the entire 6 weeks. Okay, so that's what happens if the entire ACAS period is after the date of the event, but before the date that they would ordinarily have had to issue their claim. The other possibility, of course, is that the employee or the potential claimant contacts ACAS right at the end of their usual limitation period. So in my example, perhaps towards the end of March. Now, in that situation, obviously those 6 weeks will take us beyond what their ordinary limitation date would have been. That's fine. Their submission of their claim is still in effect paused. The 6-week period will happen, which will take us beyond the 1st of April and probably into May, which is absolutely fine. They then have a month from whenever that ACAS certificate is issued on top of the time they've got. So they're always going to get their 3 months in one way or another. If they engage ACAS during the entire process using example 1, then what they in effect end up with is 3 months plus 6 weeks. If they go right to the end, then they've potentially had, for example, 2.5 months, 6 weeks with ACAS, plus another month from when that ACAS certificate is issued, and that's their new deadline. I haven't done a worked example because it is one of those things that you have to do on an individual basis because it can be a little bit complicated. But it is useful to know that in principle, at least, it's all fine and good as talking about if you haven't heard from the tribunal, then within 3 months you're probably safe. But actually in practice, what we could have is 3 months, individual contacts ACAS right at the end and says, no, I just want the certificate issued. They could have another month from then anyway. They issue the claim, it will sit with the tribunal office for another month before it makes its way to you. So actually that 3 months very quickly becomes 6 or 7 before you can actually say you're safe. It's always a useful exercise. The moment, like I say, it's the first thing you should do when a claim form lands on your desk is actually sit and calculate these periods, because you are out of time for your claimant. Is quite a useful way to create a problem early on and potentially get the entire claim struck out. As I say, I haven't done a worked example. It's one of those things that I just want to flag so that everybody is aware of. But the basic effect is if a claimant decides to engage in early conciliation, it means they've got longer to submit their claim. As somebody who has been and still occasionally is a claimant lawyer, it's quite useful tactically. I tend to encourage people to do it towards the end because it gives us longer to try and resolve the dispute, and if that's not working, it then gives us somewhere between 6 and 10 weeks on top of what we thought we had to draft the claim. So engaging in early conciliation then, how does that work? What does it look like? All discussions with ACAS are by statute completely confidential and cannot be used in proceedings later. There is pretty much an absolute without prejudice privilege involving early conciliation discussions. I have had this row with an opponent. I believe I am correct in this. Of course I do, otherwise I wouldn't have had the row. My reading of the legislation around this is basically any conversation or any correspondence that you have with an ACAS officer, whether they are exercising their initial duty, so that first 6 weeks to try and conciliate, or their discretionary power, which is outside those 6 weeks, to try and resolve the dispute, is privileged. And the only way that privilege can be released is if the person who makes the initial correspondence chooses for that information to be used in court themselves. And I think that's quite clear. So the advantage, therefore, is you can say things, you can accept and acknowledge things in correspondence with ACAS that you're probably not going to accept or acknowledge as part of the claim itself. It is the whole purpose of trying to resolve a dispute. We acknowledge that maybe we didn't quite follow process correctly when taking you through the disciplinary procedure. However, we don't think it's a £20,000 claim, but we're prepared to give you 5. That's the whole point of attempting to conciliate and resolve. The nice thing about any out-of-court settlement is there are the possibilities to agree outcomes that the Employment Tribunal cannot order. The Employment Tribunal cannot order you, generally, to provide a reference. That can be produced and agreed as part of a conciliated agreement or a settled agreement, as we'll come on to later. In very, very limited circumstances, the tribunal can instruct an employer to understand training. It can be part of a recommendation which they're allowed to produce as an outcome, but as a general rule, it's not there and they don't. An apology letter. The number of claimants I talk to who say, I just wanted someone to accept that they treated me badly. Now, I know as an employer, you are not going to write an open letter that says we apologise for treating you appallingly and not doing anything right. But a confidential letter expressing regrets, something along those lines, that may actually pacify some claimants. It is perfectly possible that an acknowledgement you've done something wrong will actually be a step in the right direction. The entire discussions take place as shuttle discussions. Those of you who have been involved in mediation will be familiar with the phrase for mediation. You only speak to the conciliator. They are not going to put you on a video call, on a phone call, or in a room with the claimant and say, sort it out. It is literally back and forth. I'll come on in a moment slightly to kind of the role of the conciliator and what they do. But you know, for those of you who are employers and are considering whether you might want to engage in this process yourself, yeah, it's absolutely the case that you will not be put in the room with the claimants to, in effect, have a row with them. That's entirely unhelpful. I said I'd come on to the role of conciliators. Well, I'll come straight on to the role of conciliators. Point 1, as much as it might seem they occasionally have done so, they are not legal advisors. Many of them are either former lawyers or people who have done law degrees and have some understanding, but they are not giving legal advice, and they are very clear to claimants that they do not give advice on how to present their claim, the nature of the claim, or what to say. Now, I appreciate, as what in most cases will be respondents, it might feel as though the conciliator is on the claimant's side to an extent. Officially, they're not. If it presents that way, it's because the claimant is usually unrepresented. And the other thing to bear in mind is no matter how sometimes aggressive or confrontational correspondence ACAS can seem, what they're doing is putting forward the claimant's position. It is probably toned down from what the claimant wanted them to say. So as I say, they won't advise claimants on how to present it. They can give general overviews of the law. So I've had a recent case where the conciliator has phoned me. I've been acting for the respondent, and the conciliator said to me, look, I've explained to the claimant that they don't have an unfair dismissal claim because they've not been employed for 2 years. And they will give advice to that extent so that the claimant understands what they probably can and can't bring. They are allowed to discuss similar cases, particularly reported cases with the parties, so that they can give an idea of what the outcomes were in those situations. I've never had that happen where I've been involved, presumably because the assumption is that my client will be taking advice from me on that. But where there's unrepresented parties, then a conciliator can say, look, I know I was involved in one where a similar case to yours only went for £5,000. I think the 50 you're asking for is a bit extreme. They can and will have those conversations occasionally. And as I said at the bottom there, they are officially independent, both of the dispute. So going back to what I said a moment ago, they're not taking sides. It might look as though occasionally they are doing more for the claimant, but again, it's probably because the claimant is perceived as being in a weaker position. They are also independent of the tribunal process. They're very, very unlikely to get involved moving forwards, and as we said, the correspondence with them is confidential anyway. Their job primarily is to try and reach a resolution, and if it feels like they're pushing you to settle a claim, it's because to an extent they are. That is part of their role, is to try and reach a resolution to the dispute. So very quickly then, if we reach a resolution through ACAS, if you look at their website, it will say that they will write up a COT3 agreement. Those of you who have been on the receiving end of a resolution through ACAS will know that in practice, they ask you to provide the wording for this. A COT3 is a short version of a settlement agreement. It's a statutory settlement process. And officially, ACAS will tell you they do not have a template for a COT3 agreement. Now, officially, again, I'm not allowed to tell you that they do, but in my experience, 99% of COT3s, certainly the ones that are available on all of our precedent banks, I've seen the ones that are available on some of the HR precedent banks, all look remarkably similar and all look remarkably templatey. They usually cover settlement of the claims, payment figure, confidentiality, a reference if there's going to be one, maybe a legal fees contribution if that's been agreed, and they shouldn't say much more than that. They shouldn't run to more than about 3 or 4 pages. They don't need to. There is no obligation for the employee to take independent legal advice on a COT3, and my view is if you're trying to put much more than those basic terms into a COT3 agreement, you should actually be doing a full settlement agreement and doing it, open quotes, close quotes, properly. And the reason I say this is there's an important caveat with ACAS and reaching disputes. The agreement is legally binding at the point when the parties agree the outcome. It's not the signed COT3 as a contract. To an extent, that is a formality. It's a document proving the agreement. And ACAS will be very, very careful in how they approach this with you. But strictly speaking, the exchange can go something like, employer offers £5,000, claimant turns around and says, yes, I accept that. ACAS then sends an email that says, well, the claimant's agreed, you now have a legally binding agreement. And under the statutory regime that governs ACAS, that is true. The dispute has been resolved for £5,000 at that point. The COT3 becomes something of a formality. That said, it is still important because it documents the agreement. But the important thing to take away from this is, before that stage, before the time when ACAS are likely to say something like this agreement is now legally binding, make sure you've covered everything. If there's going to be a reference, present it early, get it agreed. If there's going to be more than the standard confidentiality provisions, get those agreed. What you don't want to do, because it's a pain, is get resolution on what the financial settlement will be, which I appreciate is the important bit, but then spend 3 weeks trying to agree the wording of what should be a relatively simple document. So as I say, no official template, but all of the precedents are very, very similar. They all look basically the same. They're not overly complicated documents, but because they're recording a settlement, if you feel you need to, do please take advice on them. We're obviously happy to assist with those. And I think, yes, protected conversations without prejudice cropping up there. Very, very quick 20-minute overview of kind of ACAS and the role of conciliators. I'll pause briefly if anybody's got any specific questions on ACAS now. If not, I will move on and start talking about protected conversations without prejudice and settlement for the second half of the presentation. So if anybody's got anything they want to add, please do let me know now. I'll just give you a moment. As always, if there's no questions, I'll assume I'm either doing a fantastic job or nobody's listening. Okay. Nothing obviously coming through, but as always, if anything does crop up or somebody's writing a long question, I'll come to it towards the end of the session, but I'll move on now. So what we're going to talk about with protected conversations and without prejudice, these are now approaches to try and resolve a dispute that don't involve ACAS. This is where we're probably doing it ourselves. If we're a business, we may be doing it. We may be engaging a HR consultant to have this conversation. or it may well be that your solicitors are having a conversation either with their counterpart or the employee directly. These two phrases are often used interchangeably and or together, but there is a difference between them that I'll come on to shortly. So what I want to talk about is knowing when to use each of these, and then ultimately how it may resolve in a settlement agreement. Yes, I've just seen the question come in on the 6-week ACAS period. I'll come back to that because I know it's a bit complicated. I'll recover it briefly at the end for anybody who wants me to go back over that. So, without prejudice first. The without prejudice rule is a much broader legal principle than just within the employment sphere. You won't find it written down anywhere. It's a principle that's developed under English common law, which basically says that the parties who are involved in an ongoing or seriously contemplated dispute can engage in what are genuine efforts to resolve that dispute on an off-the-record basis. Okay, it doesn't matter what dispute you're involved in. So as I say, it's not specific to the employment tribunal. It can also take place in, I think, almost every other jurisdiction, with the only exception that immediately strikes me is I don't think this rule exists in family proceedings that involve children, just as a matter of public policy. There you go. Totally useless segue for you. So the point is there has to be an ongoing or contemplated dispute. So we have to be at the point where either the legal claim has been presented or at least has been asserted in order to actually have a without prejudice discussion. So it's of no use to us if there's not an existing dispute or there isn't a seriously likely one. The efforts to settle have to be genuine. So, you know, for example, if it's very, very clear that the correspondence you're sending is simply a rejection of the position, or as a claimant an assertion of a legal position, that's not an attempt to settle. There's no conversation taking place there about resolution. You are just litigating the argument if all you're doing is putting forward a position. Interestingly, without prejudice, the parties who are having the discussion have to agree to it. So what you'll often find that we do as solicitors in this situation, if we're about to have a without prejudice phone call, the first thing we will say to each other, just to ensure that is documented, is, are you happy to proceed with this on a without prejudice basis? And the reason we do that is partly because the rule requires it, and partly because of the second half of this rule. If you're engaging in without prejudice correspondence or a without prejudice conversation, the parties doing so have to have given informed consent. They have to understand the rule and the principle. And obviously the rule or principle here is we're having this conversation, it's off the record, and the idea is that it's inadmissible. The contents of this conversation, indeed the fact that it's happened, should never then appear in court in most situations. And in order to give informed consent, you have to understand that. So one of the difficulties that's occasionally encountered in the employment tribunal is an employer with knowledge of the without prejudice rule approaches an employee and says, I'd like to have a without prejudice conversation with you, and then just dives straight into it without explaining what it means. That potentially defeats the entire purpose. It doesn't happen very often, but there are cases where it's happened. There is case law on it. And the risk then, of course, is that the things that are said in that conversation become admissible. The employee turns around and says, well, I didn't understand. I didn't know what that conversation was about, so I want to use that conversation as part of my claim. So it is important that we're ticking all of those boxes if we're going to rely on the without prejudice rule. It has to be a dispute, it has to be an attempt to settle, and the parties have to understand the nature of the conversation and its effect of being without prejudice. So as I say, the effect and potential limitations of without prejudice conversation then, if it is genuinely without prejudice, it is almost certainly going to be inadmissible in the legal proceedings. It shouldn't be referred to. In theory, the fact that it happened is also inadmissible. There are situations that some of you may have encountered where things will crop up, but they are actually quite rare. The big ones where it can still be used. But without prejudice correspondence cannot be used to hide improper behaviour. So if in the course of those discussions you have well, physically or indeed metaphorically, held the employee against the wall and said, look, if you don't agree this, we're going to do A, B, C, D, serious threats, there is a risk that that correspondence is, or that conversation is then not without prejudice. And of course, it can't protect criminal behaviour. So I've used blackmail as an example there. if the way that the employer is communicating with the employee could amount to blackmail, it can't protect that. The other version of without prejudice that you will have probably seen is without prejudice savers to costs. Question as to whether that's actually necessary or not. There's a general principle that without prejudice correspondence can be used in a cost application in due course anyway. The idea here is that if you are able to apply for costs at the end of the matter, i.e. once the dispute has been resolved by the court or the tribunal, you can then refer to correspondence that was done on a without prejudice basis to say to the judge, look, you've just awarded them £10,000. 9 months ago, we'd offered 12 as settlement, which they rejected. Therefore, this entire process since that rejected offer has been wasted, and we'd like to try and get our costs for that. It is much more common that that will happen in the civil sphere. As those of you who've been through tribunal processes will know, costs are exceptionally rare. And simply rejecting a settlement offer, even a reasonable one, is not necessarily sufficient to get you a costs order. So this is useful. It may crop up in a very, very small number of cases, but as we all know, the general rule in the tribunal is that the parties pay their own costs. Other interesting thing to note, whether or not something is genuinely without prejudice occasionally forms what we call satellite litigation. It may become a distinct issue as part of the case. For example, that situation I was talking about earlier, where an employee wants to argue that a document or a conversation was not correctly done without prejudice. It can be determined by the tribunal as part of the court process whether or not a document or a conversation were genuinely without prejudice, and documents in particular can be deemed to be partly without prejudice, partly not. So the tribunal can say, well, look, these first 2 paragraphs clearly weren't a genuine attempt to settle, so we will consider those, but the rest of this bit is, so we're going to ignore it. Again, that's quite rare. Most without prejudice correspondence, when it's done, is done between lawyers who know exactly what to put in and not put in these situations. But important things to be aware of if it's something you're considering engaging in yourself, particularly with an employee directly who is not represented. On the flip side then, and one that employers are generally more familiar with, is the principle of a protected conversation. So protected conversations are held under section 111A of the Employment Rights Act 96, and they were introduced to fill a gap. So what I've just said about the without prejudice rule there is that there has to be ongoing or seriously contemplated dispute. And there needs to be something that might give rise to a legal claim. The purpose of a protected conversation is to allow you to have the discussion and talk about a potentially settled exit or resolution where there isn't a dispute, or where certainly there isn't a legal claim arising at the moment. So as I've said there, where most people use them, they're good for enhanced redundancy offers. We don't want to go through a redundancy process, and we'd like to offer you, the equivalent of 2 weeks rather than 1 week for each year you've been employed, and that is where they are perhaps most commonly used. And in that situation, of course, there isn't a dispute. You haven't started a process, the employee hasn't been terminated, so there's no unfair dismissal. It's purely exploratory. The other times, of course, where they're commonly used, we're in the middle of a disciplinary process. Well, again, there's not necessarily a claim at that point. You haven't dismissed, you haven't imposed a sanction. You are just exploring the option as a way to avoid going through that process. The important thing to remember about protected conversations is to ignore the typo in my final bullet point there, because that should obviously say inadmissibility. The inadmissibility of protected conversations is limited to claims under the Employment Rights Act. It is limited solely, to all intents and purposes, to unfair dismissal claims. So you cannot use a protected conversation where the issue in question is discrimination, because the claim, the potential dispute, has already arisen. If somebody believes they've been discriminated against, they don't need to resign to bring that claim. They could bring it immediately. So there is a dispute in play. Therefore, these are only used in those kind of situations I was just describing: a potential redundancy, termination during the middle of a performance or disciplinary process, where a decision has not been made. Be careful in capability and sickness absence processes, of course, because there could be a discrimination angle if the employee is looking at relying on a disability as the reason for their absence or performance issues. Ultimately, then, the outcome of any kind of without prejudice or protected conversation is potentially a settlement agreement. Settlement agreements are something, looking at the list, I know the vast majority of people on this call will be familiar with, so I assume most of us are. They are a heavily regulated contractual document intended to resolve the dispute. There are various statutory provisions that relate to them, and the ultimate purpose, as I've said there, is to resolve the dispute without the need for litigation. It's intended to provide this clean break to both parties, bring an end to the dispute. And I will occasionally say to employee clients when I'm advising on them, if you've understood that the gist of this agreement is here's some money, go away, don't sue us and never talk about this again, that is pretty much the gist of them. And that is to a certain degree beneficial to both parties. The legal framework for settlement agreements, as I say, they are talked about in so many places, but the vast majority of what we understand about them is the Employment Rights Act and the Equality Act. Those of you who've drafted them, read them, seen them will know that you often get that list of about 12 or 15 other pieces of legislation that they're referred to in. They all basically say the same thing. And the absolute minimum requirements for a settlement agreement are these three. They have to be in writing. They have to relate to I don't know what it was with me when I was preparing this document and typos. They have to refer to a specific claim, not a whatever that word is claim, or potential claim that is arising. And the employee must receive independent advice on the terms and effect of signing the document. That's the specific wording that's in the legislation. It's the terms and effect of signing. So it is not necessarily what their legal claims are and what the background is. The legislation only requires the terms and effect of signing the document. And that's it. So there's often, for example, the advisor certificate put on the back of them. That's not a legal requirement. That's something we put in as a contractual obligation. I suppose the interesting point about number 2 there, apart from the typo, is it has to relate to a specific or potential claim. So of course, what most people do and how the majority of these claims are drafted is there'll be a line in there that says we're settling claims even if we don't know about them at the moment, even if they're not in the employee's contemplation. There has historically been a question as to whether that can be done, because when you think about it logically, there are very, very limited other circumstances where we would waive our right to sue somebody in a situation where we don't know a claim exists. You don't buy a car and sign a document that says, I'm not going to sue you in 6 weeks' time for this thing that I couldn't possibly have known about today. Most of us wouldn't accept that, but we do it regularly in settlement agreements. The Employment Appeal Tribunal here and the Court of Session in Scotland have both confirmed that this can be done recently. I'm sure it will be disputed further, but that line about settling claims even if they're not in the employee's express contemplation, for the time being, is fine in principle. So, use of settlement agreements, commonly used to resolve unfair dismissals, potential redundancies, discrimination claims. The point is they're intended to, and it's why they appear in multiple areas of legislation, settle any potential employment claim that you might have. As I say, and the most common place we see them, enhanced redundancy packages, or to avoid some other formal procedure or process. It may well be you've got an employee going through a disciplinary process. You're not totally convinced that you'll get them over the line for gross misconduct, but the way you're going to offer it is, look, we don't want to go through this process, nor do you really. Let's talk about exit and maybe leaving with a bland reference, with a few weeks' pay, with your notice, whatever the case may be, in exchange for signing this document. Things to consider about them, then, they are much more cost effective than litigation. A lawyer is not going to cost you much more than a few £100s to draft them. You've got the contribution towards the employee's legal cost of taking the advice on them, although again, that's just custom, that's not a requirement. That it's certainly going to be cheaper than spending 18 months going through the employment tribunal, obviously depending on what you're settling for and what you're offering. There's a certain degree of confidentiality that you can include in these documents. That's going to be a benefit to you. You don't want the employee talking about what's happened, what they've been through, Or in the case of an enhanced redundancy, you don't want them talking about the extent of that enhanced redundancy payment. There are limitations on confidentiality that I'll come to in a moment. And of course, it gives you a degree of control. You can initiate this through a protected conversation if it's an unfair dismissal claim, or through a without prejudice discussion in other cases. And it gives you the opportunity to go in first and say, this is what we're thinking, this is what we would like to present. So it gives you some control over the exit date, it gives you some control over, as I've mentioned previously, whether you're going to provide a reference and what the terms of this exit are going to be. A few key elements just to think about then, the big things that are usually in these agreements, the compensation details and how they're going to be paid. So what of it is an ex gratia compensation, what of it reflects maybe injury to feelings payments, what of it is notice pay, what of it is holiday pay. That breakdown is quite important. The tax status of the various proposals is almost always covered. I've referenced the Income Tax, Earnings and Pensions Act there. So I'll just highlight very, very quickly. If a payment is genuinely compensatory in nature, so it's designed to reflect redundancy, loss of employment, injury to feelings for discrimination, up to £30,000 of that is generally payable without deduction of tax or national insurance contributions. I say generally because the advice I always give to an employee here is that's not up to us. It's an understanding of the legislation. There are situations where HMRC may determine some or all of that to be taxable. Therefore, it's important that we break it down, show the understanding, get the agreement from the employee, and generally also ensure that there's a provision that they will be responsible for any personal taxes that are deemed payable. Confidentiality and non-disclosure, considering another type. I'm sorry, folks. I should have proofread this more quickly. I'm going to blame the fact that I had to do this quickly because Nathan wasn't available to do his half for the number of typos in this. Consider the limitations, not the limitations. In terms of confidentiality provisions, you can have a confidentiality and non-disclosure in relation to the document itself and in broad terms the circumstances. There are certain things that you absolutely cannot prevent an employee from talking about. You cannot prevent them from whistleblowing. As lawyers, we are not allowed to let them sign a document. It's a professional obligation that tries to gag whistleblowing. Similarly, particularly in light of the new duty to prevent sexual harassment, it's generally not permissible to try and prevent an employee from reporting a criminal offence, from disclosing things that can amount to criminal offences. So sexual harassment is a particular example there. There's various other limitations that, as I say, if people want me to do a full session on what a settlement agreement can look like and what can and can't go in there, I'll do so, but I'm not going to get through today. So there go a few more points on the limitations, which I've now managed to spell correctly on this one. One obvious limitation here is the requirement for independent legal advice. There's two consequences of this. Firstly, as I said, it has become common practice for the employer to contribute financially towards the employee's legal costs of doing so. Those costs are likely to be in the region of sort of 350 to 500 plus VAT, but they can be more. It really depends on the complexity. As I say, there's no obligation on you to make that contribution, but it is one of the first things an advisor will check before giving advice to the individual. There are some claims which cannot be settled under settlement or compromise agreements. There are not very many of them at all, but there are a few that exist. In principle, certain claims relating to TUPE consultation, for example, are quite hard to settle properly. Again, I'm not going to go through all of those now because they are quite technical. If it's something that needs to be covered in a separate session, I'll do so. All of the usual ones, though, the unfair dismissals, the pay claims, the breach of contract, the discrimination claims, statutory pay claims, all of them can be resolved under a settlement agreement, usually not an issue. I talked briefly on the previous slide about the limits of confidentiality agreements. As I say, the big one there being you cannot prevent genuine whistleblowing. So if an employee is aware or has suggested that they might be preparing to disclose breach of regulatory duty, environmental damage, health and safety issues, for example, there is absolutely nothing that we are allowed to let them sign that would prevent them from doing that. It is it is not only a general legal principle, but is also, as I say, a specific regulatory rule that we are instructed on. And that's it. That's everything I wanted to talk about on ACAS, COP3s, protected conversations, without prejudice discussions and settlement agreements. The next session will be Wednesday, the 6th of November. As I said at the start, it won't be me. I'm hoping I'll be having a nice time in Rome that week. So Nathan will be doing a longer session than he had planned for today on internal workplace dispute resolution, the role of mediation in trying to resolve legal disputes, or more generalised workplace disputes before they become legal ones. And then, as I say, the subsequent session in December will probably be on issues arising post-termination, and that will get us towards the end of the year. So I'll now start looking through questions. We've got sort of 5 minutes before the session would have ended anyway. Feel free to hang around while I deal with questions, but if anybody needs to go or wants to go, please do be my guest. So I will start by cycling back to the 6-week point under conciliation. So the question is, can I ask when the 6 weeks came in? I think it was the exact question. Yes, that was changed. I can't remember the exact date. The best I can give you is in the last year or so. Almost any early conciliation that you are dealing with now will be engaged under that 6-week period compared to the 4 weeks that it used to be. I'd have to look it up to give you the exact date it came in if that's relevant. If it's something you want to talk to me about kind of offline, then please do, because if it's going to impact on deadlines for a claim, that's obviously quite important. Next question I've had then, is there a better way to enter into a settlement agreement? Is it better to have a protected conversation or without prejudice conversation? It depends on the circumstances, quite frankly. Protected conversations are absolutely fine if you are absolutely sure that the only claim that's likely to arise is an unfair dismissal, or there is no existing claim at the moment. If an employee hasn't mentioned anything that could amount to discrimination, you're perfectly safe to have a protected conversation with them. It is just a case of ensuring that they understand what is going on and they're prepared to enter into that conversation. It's useful to start either without prejudice or protected conversation in exactly the same way. This is a conversation we're intending to have on a without prejudice basis and or protected conversation under section 111A. What that means is, and then explain the relevant effect. So there is no better one because it really depends and it cuts both ways. If there's no existing dispute, then it cannot be without prejudice as a matter of principle. For written correspondence, you can try and put both on there and try and give yourself the protection of each, but ultimately, if the admissibility of that document is called into question, it will be for you to prove that it was either genuinely without prejudice or under a protected conversation. So no is the short answer. There isn't a better way to do it. It really depends on the specific circumstances as to which of the two rules is most applicable. One doesn't afford more protection than the other necessarily. Can I give an idea of what's typical for compensation in a settlement? No, I can't, because there is no typical settlement. Everybody will be bored of "it depends" from employment lawyers and lawyers generally, but it genuinely is the answer in this case. An unfair dismissal or an enhanced redundancy compensation, I would usually expect to see payment in lieu of notice. An enhanced redundancy pay is usually one of two things. It will either ignore the statutory cap on a week's pay, so that's the £700 if somebody earns more than that, or the multiplier will be done differently, and they'll say instead of giving you 1 week's pay per year of employment, we'll give you 2 weeks. That's generally what I would expect to see, and I'm not saying those exact figures, but that's sort of a general overview of what I'd expect to see in an enhanced redundancy settlement offer. The other one that occasionally crops up, and as an advisor to an employee I would always question, is where what is included in the agreement doesn't seem to be much more than statutory entitlements. They're often the weirdest ones that we receive. Bearing in mind that notice pay is non-negotiable unless you're potentially going to sack for gross misconduct, there is no point producing a settlement agreement that is just notice and basic award stroke statutory redundancy, because what is the employee agreeing to? What's the benefit to them in that situation? It may be appropriate, you might be very, very close to a genuine gross misconduct dismissal, in which case they'd obviously be entitled to neither. But in the vast majority of cases, the first question that I would ask as an advisor in that situation is, why are you waiving your rights to sue what could be for an unfair dismissal if all you're getting is statutory entitlement? In terms of settlements for potential discrimination claims, that is simply how long is a piece of string. There's no scientific way of calculating the value of a discrimination claim, even when you're in the tribunal. Forget trying to do it for settlement purposes. It's always a balancing act, and ultimately I think what you end up paying in that situation is going to depend on what advice the individual receives and how willing they are to proceed with a sort of more extensive negotiation of the claim. So that was a very, very long-winded way of me saying, no, I can't give you that answer, I'm afraid, but it is because legally every claim in the employment tribunal is dealt with on its own individual merits. So logically, that must be true for settlement as well. Okay, I think that is all the questions I've had. I'm hoping I've covered both of those for you, but please let me know if there's any follow-up from those. If not, that is just about 11 o'clock. I will see you all in December for my next session. Nathan will see you at the start of next month. And as always, everybody, thank you for paying attention. Thank you for joining. Have a good rest of your day, and hopefully a good October as well.